Hello, and welcome to Chartwell Law's Workers' Compensation Quick Hitters, the place where you can get all the information you need on Pennsylvania workers' compensation in 5 minutes or less. My name is Jonathan Spadea. I am joined, as always, by my partner, Matthew Esslinger, and we're here today to discuss the first in our series on affirmative defenses. Before I kick it over, just a brief reminder that nothing here today is legal advice, and every case is different. So with that in mind, please feel free to reach out on our website, chartwelllaw.com, for further questions and information. With that, Matt, please take it away on what we need to know about the affirmative defense of positive work order.
Thank you, John. And as John indicated, these are quick hitters. So we understand your time is precious. We're going to try in these series to give you a couple takeaways for these various workers' compensation topics. With that said, positive work order appears at its outset to be a very common sense defense. I will say it's in a defense, it's an affirmative defense, meaning that the employer has to prove these things. So essentially you have a situation where you would say, well, this claimant was injured and they were injured as a result of ignoring a company rule. They should not be able to benefit as a result of that ignorance, and therefore they should not be able to collect benefits. So for the employer to be successful in this affirmative defense, they had to prove three things. One, that there was a company rule in place that the employee ignored, and as a result of that was injured. Second of all, the employee needs to know about this rule. Third, and this is the prong that we find most difficult in courts, is that the rule is not connected to the employee's job duties. What do I mean by that? I'm going to give you three different situations. One, you have somebody who is working and they are not certified to drive a forklift. However, they decide to drive a forklift and are injured. In that instance, I would argue that they were performing an activity that was both a violation of the company rule. The company rule in this instance is you have to be certified to drive a forklift. And B, that driving the forklift was not connected to their job. Compare that to a different situation where you have a factory worker making tools. The machine they're using to make the tools is jammed. The company has a policy that they're not supposed to unclog jams, but sometimes they allow it to happen and they want to keep a certain quota. The employee gets injured while unclogging a jam. And in that instance, the employer says, well, this is a violation or a positive work order. The courts, unfortunately, have said, well, no, this is part of the company or the employee's job duties. Therefore, you don't meet that third prong. Let's look at the last situation where you have a truck driver driving a truck, gets a flat tire, decides to change the flat tire. There's a company rule that says there is a separate company and or maintenance department to change the tire. It's not part of your job duty to change the truck tire. Therefore, when the argument for violation of positive work order is asserted, the courts say that this injury is not compensable. So what are your takeaways from this quickly? Your takeaways are document everything. This not only applies to this situation, but other workers' compensation situations. But in this situation, make sure you document what the employee's job duties are and what they're not. Therefore, you can show that these are the job duties the employee is supposed to do and what they're not supposed to do. Also with that, document when the employee is told these are the work duties and these are things you're not supposed to do. Second of all, be consistent with your rules. If you're going to say this is a rule and don't do this, for instance, if you have employees who are not supposed to drive forklifts, if they're are not certified, make sure that if you have employers that see that happening, that they tell the employee immediately and every single time, or as best of their ability, don't do that. Again, be consistent and document. Those are your takeaways.
Thank you, Matt. That was the first in our series, the positive work order defense. Stay tuned with us for the next installment. And if you have any questions, once again, please feel free to reach out to us from our website, chartwelllaw.com. You can find all of our contact information there. Thank you.